public comment sheet located at the entrance to the meeting room.
All right, thank you. Now we'll have approval of minutes.
So moved.
All right, thank you. Member Brown? Is there a second?
Second.
All right, thank you, Member Holloway. All in favor? All right, our minutes have been approved. We'll now have chair remarks. On July 18, 2023, Metro Council unanimously passed an ordinance reconstituting the Metro Nashville Community Oversight Board in response to the Tennessee General Assembly's continuous overreach. I'd like to thank the sponsors of this recently passed ordinance and say to the public and the community, the work is not over. We are not done. As long as there are policing our streets, our communities, it will be our responsibility, along with the community, to monitor police and community interactions and take complaints of alleged misconduct. So that is just a reminder that we are still here and we are still doing the work. All right. Now we have an ordinance update. Director Fitchett.
Hi, good evening. So we met multiple times with the council. We reported there on July the 6th and the 18th. It was passed. June 20th was the first. It passed on a consent. And then on the 6th, it passed by a unanimous vote. And on the 18th of July, it passed by a unanimous vote. And it basically had only one or two amendments. The first one being that the effective date changed to October the 27th because the 29th is actually a Sunday. And that is when we have to have the reconstitution done by October the 27th, 2023. And then there was another ordinance change, and it was just some cleanup language in that. And so we're very pleased that it passed, and we are looking forward to continuing the conversation about preserving as much of the things that we could in our charter. And that's it.
Any comments from board members? Any thoughts on the ordinance? Good. We'll move on to the executive director's report. Director Fitchett.
All right, thank you. I'll just hit a couple of the highlights. We hired Brazil and Clark to assist with the completion of proposed resolution reports while our legal resource advisor is on an extended leave. We had an executive committee meeting on Wednesday, July 19th, and the next board meeting here, it's going to be in August. I don't have the actual location, sorry about that. This month we received, since our last board meeting, we received 8 complaints. Hold on one second, let me update that. I just sent you guys an updated version of that. We received a total of 8 complaints of misconduct since our last board meeting, June 23rd. We had a total number of 8 dispositions issued. We had over 20, I think we end up having 44 non-complaint contact calls, and we requested 2 records. And that takes me into the records issue. I wanted to invite Assistant Director David Kiley into this records update because we submitted 3 records requests for police records, and we have not been able to receive some of those records. And so, Dave, if you'd like to jump in here. Yeah,
so my understanding from the police department's legal counsel is that they believe that the MOU, the Memorandum of Understanding that allows us to get those records from the police department, the department believes that MOU is essentially canceled by operation of law because our old state statute had provisions in it that protected the confidentiality of those records. That statute has now been wiped out by the legislature. However, the new statute contains similar provisions, so we are hoping to continue that conversation with them. For the meantime, however, the department's position is that they cannot give us any, at least confidential records. And my understanding from officers is also that the chief has rescinded all orders to participate in our interviews. So in terms of getting anything from MNPD, at least until we have a new MOU hammered out, it looks like we are just not going to get anything from them, unfortunately.
So, first of all, board members, if you want to chime in, Goddard, Member Goddard, go ahead. No, you go ahead. So what I wanted to kind of reiterate, and I want to make sure that it's very clear, A.D. Kiley,
yes,
is that you are saying that the chief has rescinded all interviews, and so no police officers are complying with our interview request?
I want to be careful I say that. That has not been communicated directly to me or anyone, I don't think, by the chief or the department. I have been given that information secondhand by Fraternal Order of Police attorneys who were appointed or hired, whatever you want to call it, to represent subject officers. So when we have reached out post July 1, when we have reached out to schedule interviews, what I've been told so far, and this is one or two instances, was that the chief has rescinded the orders and the officers are therefore not going to participate. One of those officers did offer to participate by maybe like written correspondence, but my understanding, at least the FOP's position, is that there are no more orders to interview.
And so all records that have been requested, we have not received them.
And so that's a separate, that information did come directly from the department. So we had submitted records requests. Those came back with public record request forms basically saying, we're denying your request based on Rule 16 and some case law. And so then we reached out to the department to get clarification of their legal position as it relates to our MOU. And that I was given in writing, which is their position that because the old statute is no longer in effect, they believe that the MOU is no longer in effect. And I'm optimistic we can get a new one because I think the law is there for them in the same way. But until we do that, it seems like their position is to not furnish us with any records.
So where do we go with the October 27th effective date? How does that play into us not being able to, or MNPD not submitting records that we've requested? I mean, where does that fall in line?
Honestly, I think that would be up to a court to decide. I mean, I do not think they are incorrect in their position, but I think that I think they have a legal basis for their position. I think, however, there is also a legal basis to just make a new MOU. So I don't think, you know, I want to be careful what I say because I don't want to misrepresent their position, but in terms of what a court would say, I can't tell you. I can tell you that if the new MOU is in fact canceled by operation of law, there is also no reason that we can't just draft a new one, because the new law gives them the same coverage, I think. The new law gives them the same coverage to disclose confidential records to us and have those records be protected, because that's the important part. The new law says, just like the old one did, if MNCO gets confidential records, we can't release them. So the new law gives them the same protection that the old law did in my reading. It's just a matter of getting a new MOU written. I have proposed that and have not been given a response.
And I'd like to jump in here, please. What I would say is, and we had this discussion regarding the MOU, I do think that it's a discussion that we have to have with MNPD, Metro Legal, as well as the District Attorney's Office. I will say, as you noticed, that MNPD did not send a representative here today. So it seems to me like their position is that we have been abolished. and that the reconstitution does not necessarily include them in this particular operation that we have. And so I just want to take note of that. I want people in the public to understand that we are not getting records. We have until October the 27th to complete open investigations, and they are not cooperating in that regard. And because they're stating that the MOU is no longer, I'm not going to say legal, but there's no longer an agreement with that. I think that it's up to us to move quickly so that we can continue this work. We have hired an outside agency to help us do this work. It is costing us money to do this work. And so I just wanted to make certain that I put that out here so for all of you to comment on if you want to.
Thank you, Director Fisher. Member Goddard?
Yeah, a couple of points. I'm not going to contradict anything that's been said. There are two MOUs, first for clarity. We have one that's sort of everything but Rule 16 information. And Rule 16 information is information that's confidential because it still is in the hands of the police and still relates to an ongoing criminal investigation. And any lawyer that knows better now when I say something wrong,
that's right.
Jump in. Most of the stuff relates to an MOU that we are renegotiating right now between the COB and the police department, period. There's a separate one-page and then some signatures MOU that's those two parties and the district attorney. And the workaround we've got, perfectly legal, but the workaround we've got is the district attorney has access to all police records. And he can make a decision to give those records to other parties, where there's confidentiality, right or wrong.
So in terms of our MOU, I think the district attorney can provide those records under the cover of the statute that forces us to keep them confidential.
Right.
So it is kind of a daisy chain of...
I understand, but the negotiation back when was as long as we have an obligation of confidentiality. That one specifically referred to that statute that's gone, but that's there. And I think he is a critical player in this. I believe there's a lot that's gray, there's a lot we may wind up at court or whatever else, but if he came down saying that there was a basis for confidentiality, either in statute or agreement or whatever else that was good enough for him under Rule 16, I believe that would go a long way towards us getting those documents. I'm not the one to make that conclusion for the board or call Glenn Funk or whatever, but I throw that out there as something to be considered. Second, I'm very concerned about documents after October 27. The statute does say we have to keep confidential documents confidential. It also says we aren't entitled to anything that's not a public record, period. And how that plays out, I could be optimistic, I can be cynical. We just got to wait and see.
Yeah.
Thank you.
Well, I will say thank you for your comments, Director Fitchard. I do believe that cooperation from MNPD is not only necessary, but it is a necessity, at the very least, until we get a new MOU. But also, that effective date of October 27th, Metro Legal, Metro Council, we're all in agreement that the effective date, which was amended to the ordinance, was important enough for us to close out the cases that we already had open, right? For people to get closure, for people to get answers, for us to decide and provide a determination on the issue of misconduct with MNPD. So if everyone else thought that it was that important for us to attach an amendment to the ordinance, then I would think that MNPD would also think it would be important for them to share records with us and provide police interviews, send representation, right, to the meetings. We still have a few months to go as we operate as Metro Nashville Community Oversight. And so it's critically important that we have cooperation and that people understand that the work is not completed, it's not done, and we will not leave it unfinished. So, Jill, we may need to have a meeting with Chief Drake so we can hear it from, his mouth and have his stance on record, because I know he was very cooperative, when he got here. And so we don't want to go back, we want to move forward.
Right, the chief can make that determination, and I think that we should request a meeting with him as soon as possible.
Okay, thank you. Member Witzel?
I'm just curious to know if we were notified that there would not be, that our liaison would not be here today?
I didn't receive any notification. I left my work cell phone, full disclosure, at home, but I also have email. I did not hear from Commander Lara. I will say that at the last meeting, he continued to tell people that, from my understanding and what people had mentioned, people from the public had mentioned to me, was that he said it was our last meeting. So I don't know if there was just some misunderstanding about that, but I'm not really sure.
Thank you.
Or he could be stuck in traffic. So we shall see.
If I'm not here on time, don't assume I'm not coming.
Okay.
It may be traffic.
All right. Member Holloway?
Yes, we realize that we still should be able to get reports from the chief, and like you said, set up a meeting with him and get it from the horse's mouth. The FOP though does not run the police department. They represent it as a bargain agent for a pay raise, and they need to understand it. Can you hear me now?
He is on.
It's on. Okay, like I said, the FOP does not run the police department. They are a bargain agent for a pay raise for the police department, even though they have attorney to represent their clients. We can go, if we get the information that we need to complete the investigation, we can proceed without them. It's just like having a hearing without them. We just need to make an offer if they want to come to our hearing. If they don't, then we just proceed without them. But first, we just got to get the understanding with Chief Drake. You support us in the beginning, do you still support us? And if not, then we need to do a news press release. Thousands of people voted for this organization. 100,000 people. And their voices still need to be heard. They need an independent agent to support them, do an independent investigation other than the police department. And they are very concerned that we need to continue to go forward, and they need representation. And they will hear from us soon if we don't get information that we need to complete our investigation.
A.D. Kiley and...
Yeah, just very quickly, I wanted to add to Board Member Holloway's point. It's a good point that there are two different things happening. So if the officers refuse to come in and participate, that doesn't actually stop us from doing anything. We do not have the power to compel them to come in. And so if they want to waive their participation in the process for due process purposes legally, that's fine. We'll just go ahead with a report. It's up to them whether or not they want to tell their side of the story. In terms of the records and the body cams, that is, and coming back to what the chair was saying, that is the critical thing. And the part I would add to that, and the police department knows this perfectly well, is that we lose jurisdiction over a bunch of these cases at the end of October. And so if they do not provide us with those records, they know perfectly well that we will lose that jurisdiction. And so that is why the access to those records needs to be addressed soon. And I think that when I posed that question to them, it was at least a week ago, and it's been crickets. So that clock is running down. They are aware of it. And I think there is a new provision in the law that allows them to give us the records just as they did before. And so I will say that as plainly as I can. This can be fixed in a matter of hours if they want to.
Member Turner?
Someone has a couple questions just for clarity. One, the correspondence about the MOU or the cease to even bring representation as we know of right now to the meeting, them feeling like the meeting last month was the last meeting, and that basically they feel that we are basically abolished or non-existing at this moment, even though we're meeting that came from FOP. Most of that, most of your communication came from FOP that they were responding to you.
If you're asking if their legal position came from FOP, I don't know. I can tell you that FOP lawyers talking about individual officers have told me all the orders have been rescinded. The FOP hasn't said anything to me about body cams. That's outside of their...
Right, but as far as their, the officers themselves, they were representing that particular officer?
Yes.
That was that, okay.
Yes.
For clarity, I just want to be very clear.
Yes.
That's why I'm asking. So the chief does have the power to say, let me give you this information. I want to be clear about that.
So, and this is why it's important that we all sit down. I mean, the police department is governed by a series of regulations, including federal regulations that govern what information they can disclose and to who and to how and how and why. And those regulations are not uniform, so their use of terms like public, non-public, all this stuff gets very thorny. What I will say is that the new law has the same protections as the old law. So legally, I do not think they are in any different position than before in terms of what they can disclose to us.
But the chief can make that decision to say, let's go to move forward or continue.
Yes.
Okay.
Yes, because that's how it was before. The chief can authorize the MOU and disclose as long as there's a legal basis. And so that's why I want to be careful about what I'm saying. To me, from my reading, it is very clear the law is the same, and we could just essentially swap out the statutes and
So last
make
question.
a few other tweaks.
Yeah, last question on this. I wasn't here on the board when the MOU is currently established. How long did it take to get that with the cooperation of the police department?
You were here before me, so that was actually before my
So,
time.
yeah, so
I think
okay.
Director Fisher.
We initially had two. We
Okay,
had one
right.
with Chief Anderson, which was kind of like a basic one. And then when Chief Drake was appointed to the chief's position, it took a matter of months, like a couple. Like I think he came on in October maybe, and I think we signed the MOU in December.
Just one little timeline. I just wanted to see their cooperation. I see right now that it's kind of not, or they're not cooperating. I just wanted to get some clarification on my end. All right.
I'd say that's accurate.
Thank you. I do believe that we have to continue to move about in a fair, unbiased, and cooperative way with MNPD, right? I do believe that that is a necessity, and since, and Member Turner, that was a good question, just because the MOU has already been drafted. It was signed, and so if we're talking about a few tweaks, if you will, to the current MOU, Member Goddard, I know you've been working with MNPD on the MOU negotiations and language, and I think, for what it's worth, that talk and those discussions should continue on. And it would be, Member Turner, in my perspective, that it would go much faster because we already have an MOU, so it wouldn't take 2 months. At this point, it could be a matter of a couple of days. Is that right? If we tried really hard.
That's what I'm saying, is that those provisions are in place. We've been working under the existing MOU. You could tweak it. It's not, it's not reinventing the wheel. It's not writing a whole new draft. It would just be saying, hey, maybe you can't do this anymore, can't do that anymore. That's fine. But yeah, we need to get those discussions underway for sure.
Okay, thank you.
And I just wanted to say as a reminder, I've been doing this position and working with this board for 4 years. And when Chief Drake took office, he came to this meeting and said that he was going to give us his full cooperation, that he supported the board, that he knew that this is what the people voted for, and like he was interested in making certain that whatever he needed to do to move us forward, he would do that. That's the pledge that he made, not only to the board, but to the community as well.
Thank you. Thank you for that reminder. Being a Nashville native, I know that community means a lot to Chief Drake, and we appreciate that. Director Fitchard, did you complete your ED report?
Just have a few couple things that I think are important. Myself, A.D. Kiley, and our lead research analyst, Mr. Gavin Williamson, presented to the DA's grand jury, which was very interesting and exciting, and we were very happy to do that. And so that was a meeting. I also have a meeting scheduled with someone from NOAA, their criminal justice committee head this week, as well as we were invited, to present on license plate readers to the IMF this Wednesday at 12 noon. And so that would be broadcast live on Facebook as well, but I'm inviting any of the board members that want to come to that. The other thing is I wanted you to just be reminded that NACO is having their annual conference. And so we have, some of the office staff and myself are attending that. And then we've continue to do community outreach. We're partnering with North Nashville Night Out. They invited us to come and share information for an upcoming back to school outreach endeavor. And I wanted to talk a little bit, just real quickly, about our office space. There was a conversation, and I've been talking about this over the last 6 months, probably over a year now, about our office space. And right now, 2nd Avenue looks like a war zone in front of our building. Right now they have stopped mostly all of the foot traffic to get into the building. And I received an email from the Public Property Department of Metro stating that they had extended our lease. Now, they had mentioned early in the year that they were extending our lease into the end of 2023, but for some reason, without our knowledge or even having us a part of the discussion, they extended our lease to next May. And so I just wanted to let you know that, because that was not something that we were anticipating on moving the first part of the year, since we had looked at a couple different places. And so that's been placed on hold. And I sent them an email saying that I want to be included in the conversations as it relates to our location. Our location is not easily accessible. Right now, I don't think anyone would come to our office. And just to say, we had 8 complaints this month. If we needed to interview anyone, of course, they're always welcome to come to our office, or we can meet them out. But the complaints are not easing up. People are still complaining about a host of things, a host of what they consider or allege misconduct. So having a location that is accessible is super important, so that community members feel like they have that anonymity, and they don't feel like they are being like they don't want to. They've just point blankly said they don't want to be in the building where the district attorney's office is. And so I just wanted to put that out there and let you know that's happening. And then I'm going to wrap up with this legislation. I still get calls. People are still concerned that a bill passed that suppresses their vote. The 134,371 people that voted for the Community Oversight Board to do the kind of work that we've been doing, the oversight that they voted for, is still a very big topic. I get calls a few times a week about that. And so I just wanted to make certain that we center that when those voices call to complain, to support us, and then also to talk and to show their frustration about this legislation, this ordinance, and all of that. So that concludes my ED report. Thank you.
Member Brown.
This is kind of a question for Director. I know the parking and 2nd Avenue is closed there. Is there any way that we could reimburse people if they park up at the Metro, under the Metro parking lot there off of Jefferson's
The courthouse.
courthouse? And could reimburse people for that, because it seems to me like that would, as much as we can, alleviate the problem of people being able to come to the office in person.
So right now, I have paid parking at a parking garage across the street. The problem is the street is all blown up. Right? So, so that's a problem. The other problem is when people come, I can check on Metro government's parking garage, because with our system, it's a little tricky, because if I don't know you're walking in, you would not get the reimbursement, right? Because you have to get a code first. So I can check with them. The last time I checked with them, they said that we had to buy a monthly parking permits. They don't have a reimbursement system where you can just validate. It is, you have to like say, I'm gonna buy 3 permits a month, and you may not ever use them. So yeah, they didn't have a validation type of issue, but I can still check with them.
Yeah, it would make sense if somehow we could reimburse people. I mean, they'd have the receipt, and we know what they charge per hour, and so.
Yeah, the reimbursement
It would be nice
thing.
if they had a validation.
Now, the validation thing would be better. I think they're not, a reimbursement, you would have to be a vendor and go through a whole big procurement process, so that's not gonna work. But the validation thing.
Of that.
Yeah, the validation thing might, I mean, they may be considerate of that, since our street is tore up. Like it's, I mean, right now you can't walk down the street. They have the pedestrian foot traffic stopped as well.
But you know, I do think we ought to, and Member Brown, thank you for that comment, but I do think this deserves and warrants more attention, just because of the location and the inaccessibility of the office. I mean, that's a major problem when we're talking about working with community members, receiving complaints, making sure that alleged victims of police misconduct have ease of accessibility to, make their voices heard. This is all about the community having access to a board that provides oversight as of right now. And I think it's of critical importance for us to raise this issue. I am at the office, I've been there quite a few times, and it has not been easy walking up the street of 2nd Avenue, and fencing is surrounding the front door. And so I think when we're talking about community members of all ages, races, ethnicities, disabilities, ease of accessibility is a critical part of them having access to our services. And so, Jill, Director Fisher, we may need to circle back around with on that issue as well, so people can have access to oversight services.
Yeah, I appreciate that. Thank you.
All right. Any additional comments?
Just a quick question. So, if I may, Madam Chair, if to you, to the Executive Director, on the office space, and it might be a legal question maybe, but for the office space, if a nonprofit or corporate entity offers space for free, can we accept that?
I think that we could consider it. I mean, you still would have to go through the Metro Property Director to see what that entails. But I do think that would be a fantastic thing if somebody wanted to donate us some space. Right. I wouldn't be opposed to it.
Right. Okay. I just wanted to ask that question, and for the public, someone listening, that if there's free space, since the space that we are in now is really inaccessible. Yes. No one can walk there. It's in the same office as the DA, and it can be intimidating. And parking, anyone who comes to downtown Nashville know how parking is and the expense of it. So as we're looking, if there might be an opportunity, I believe, if someone has space to offer it to the community oversight staff. So I just wanted to ask that question. All right.
Good point. All right. It's now time for public comment. Do we have any public commenters? Anyone would like to make a public comment?
Did we have anybody sign up? You can, if you want to, Mr., come on up. He signed up. Carlton Myers.
Is that Carlton?
Just introduce yourself, and you have 2 minutes, sir. Timekeeper.
Okay, well, good evening, everybody. My name is Carlton T. Mears II, Esquire. I'm a national policing reform and public safety expert and consultant, and I've been hired, I don't know, for the past 4 or 5 months now, to work with the COB and its staff on doing an assessment of its civilian complaint process. And this has now evolved into how we can take the information from that assessment to now look forward with the COB's, new responsibilities and duties. What is that going to look like, considering what you've already been doing, your strengths, areas where, you can be stronger, and what is that going to look like going forward so that you can still be an effective oversight body. Something that I've noticed, at this point I'm reviewing the COB meetings, and I started from essentially the present, going backwards. Now I'm in June of 2020. So like Sean Winsell, I've seen you several times over the years. It's good to see you in person. And Halloway and Goddard and others. It's just good to see the history of this organization and this body, and not only of the members and the staff, but I think most importantly the community members who worked really hard to get this board together and on the books, because, they want to be safe in the community. And being safe is not only addressing crime with criminals, but it's also addressing law enforcement officers who are not doing what they're supposed to do, which, I think that's pretty basic, right? If you work at McDonald's or even at Goldman Sachs, it's going to be the same thing. You want to make sure that your employees are doing what they're supposed to do, and if they're not, there should be consequences. In this case, with law enforcement, the bosses or the employers are the taxpayers. Law enforcement salaries and pensions come 100% out of taxpayer dollars. And so that dynamic in our democracy looks very different than if you were an employee at a Goldman Sachs or McDonald's. So because of that, you need to have entities like a community oversight body in place to make sure that accountability is there, and also to make sure that, the communication is always occurring between the community and law enforcement. So, I'm honored to be here and to be working with you and to meet you, and also with your staff, and look forward to continuing with the work and anything I could do to help out.
Appreciate it. Thank you so much, Carlton. We appreciate your work.
We do. All right, that concludes public comments. We will now move on to proposed resolution report. Director Fitchard.
Because of the complexity of the proposed resolution report, Director Kiley is going to do the presentation for the proposed resolution reports today.
So stop me if anything I say doesn't make sense, but so briefly, this is PRR, this is case number CC2021-038, and it involves 1 sergeant and 5 detectives. So on July 12th, 2021, the complainant filed a complaint with MNCO alleging that employees of Metro Nashville Police unlawfully entered and searched her home without consent and without a search warrant. The complainant further alleged that the officers denied her access to her minor grandson during that incident, and that they interrogated him without a guardian present. Finally, the complainant alleged that Sergeant 1 and Detective 4 were discourteous when Sergeant 1 shut the door in the complainant's face twice, and Detective 4 instructed the complainant to use the restroom with the door left open. In terms of the policies, we looked at this under obstruction of rights as it relates to search warrants, warrantless searches, and custodial interrogations of juveniles. We looked at the MNPD manual policies on intimidation or coercion, discourtesy, and deficient or inefficient performance of duties. So in terms of findings of fact, on July 12, 2021, at approximately 3:10 p.m., the complainant received a call while she was at work from her granddaughter saying that MNPD were, quote, at the door with guns and everything. Complainant arrived home and saw about 10 officers and 7 police vehicles, but she spoke principally with Sergeant 1 and Detective 4. During those interactions, she learned that her juvenile grandson, along with his 2 older brothers, who were both over the age of 18, were all being detained within her residence. The complainant requested to go inside her home and to be present with her minor grandson, who was 15 at the time. While the complainant was present, she observed officers enter and search the home without a warrant. When the complainant tried to see inside of her home, she said Sergeant 1 shut the door in her face and said she was messing with the investigation. The search warrant later arrived at approximately 7 p.m. During that wait time, the complainant asked to use the restroom, and Detective 4 escorted her inside and told her that she had to leave the door open while she used the restroom. And I want to keep this part brief, but Detective 1, during his interview with MNCO, stated that he was aware that the minor subject was a minor and that he did consider his age before questioning him, but felt that he understood the conversation that they were having. And I want to try to keep this in order without being too confusing. So basically, while they're waiting for the search warrant to come in, the 3 subjects are all detained inside the home. The complainant asked if she could enter the home. She was waiting outside. She asked if she could enter the home, but Sergeant 1 responded to her, quote, "Ma'am, you can go in the house, but if you go in the house, you're going in handcuffs and you're not leaving," end quote. Body camera footage shows complainant asking Sergeant 1 if she can speak with her grandsons, to which Sergeant 1 responds, "We're not doing that right now," and again states that if she enters the house, she'll be placed in handcuffs. The complainant confirmed to Sergeant 1 that all 3 suspects were her grandchildren and that the minor suspect lived with her at that residence. Body-worn camera footage shows Sergeant 1 enter the residence with all 3 suspects. It shows him directing other officers to give Miranda warnings to the 2 adult suspects and the minor all at the same time. Detective 2 then gives Miranda warnings to all 3 suspects and asks if they understand. When he asks the minor suspect, his response is inaudible, and it cannot be seen from the body-worn camera whether the juvenile nods his head or says yes or no. Body-worn camera footage also shows Detectives 2 and 3 with the minor in the living room, asking him if he knows why he's being detained, asking him why he has an ankle monitor on, asking him about stolen cars and guns and his supervision, him being supervised by DCS. Body-worn camera shows Sergeant 1 having other officers bring the minor suspect to an upstairs area, and I'll get into more detail about that, but in that upstairs area, the minor is interrogated by Sergeant 1, Detective 1, and Detective 4. And during the course of that interrogation, the minor asks Sergeant 1 if his granny is still outside, and Detective 2 tells him, yes, she's out there. Sergeant 1 says, no, she ain't coming in here. And I'm going to get into a lot more of the detail as we get into the actual allegations. So allegation number 1 was obstruction of rights as it relates to an unlawful search. That was raised by the complainant. In reviewing that allegation, it was determined that the officers had sufficient probable cause to perform what's called a protective sweep in the home. The information that supported that probable cause determination was that a black Honda Pilot, the SUV, was present at 2 shootings in one day. One of those shootings was fatal, one was non-fatal. A victim of the non-fatal shooting showed Detective 5 a photograph of someone he identified as the shooter. From that information, the juvenile, in this case, was developed as a suspect. Location data from an ankle monitor that he was wearing through DCS put him in the area of the shooting. The officers personally observed two of the juvenile's brothers driving the black Honda Pilot to the complainant's residence before going inside. The Honda Pilot was confirmed to be stolen by its tag numbers. GPS data from the ankle monitor worn by the juvenile confirmed he was inside the residence as well. So the review of the body cam showed the officers conducting a lawful protective sweep. They searched the areas in the house where someone could hide. They do not go into any drawers, cabinets, anything like that. And just briefly to explain, a protective sweep allows officers to perform a kind of perfunctory search of an area where they think that armed suspects may be hidden. It does not allow them to search wallets, desks, under drawers and all that kind of stuff. So in terms of the obstruction of rights, unlawful search, we did not find a violation. It appeared that the officers were perfectly in policy and conducted that protective sweep appropriately. The second complaint was as to discourtesy as against multiple officers, and so we looked at several interactions between the complainant and the officers. During the first one of those, the complainant is told by the officers that the interior of the house has been frozen while the officers wait for the search warrant to get there. The complainant was properly advised that she could not enter the house. She was told why the three were being detained. She was told about the stolen vehicle, about that there were guns in the house. So all of that was explained to her properly. During the second interactions, the complainant approaches the sergeant, at which point he tells her, makes these statements about how she can enter the house, but if she goes in, she'll be handcuffed. So while officers are allowed to freeze a scene and keep people from entering a scene while they're waiting for a search warrant, there's nothing that we could find in a policy that would support how the complainant could have been lawfully handcuffed. MNPD policy 18.50.0.20 discusses the use of restraints or handcuffs in the context of securing prisoners, persons being arrested, and unruly subjects, none of which applied here. MNPD policy 15.10.030 and 15.10.040, which pertain to the service of search warrants, similarly do not authorize any use of handcuffs. Therefore, while the sergeant's statement to the complainant, quote, just because you're in handcuffs doesn't mean you're going to jail, may be accurate, is unclear what legal basis Sergeant 1 would have ever had to have handcuffed the complainant. Furthermore, the body camera footage does show the complainant, as she described, asking officers to keep the door of the residence open. When the complainant asks the officers to leave the door open, please, and this is after several exchanges, Sergeant 1 first politely tells her no, but he then pushes the door closed and raises his voice, essentially shouting, "I'm not doing this, shut the door." The tone, volume, and forceful closing of the door by Sergeant 1 were unwarranted by the circumstances. The last discourtesy interaction we looked at was as between Detective 4 and the complainant. The complainant came to the front door of the residence asking for water, which Detective 4 provided her. And later, the complainant asked to use the restroom. Detective 4 explained to her that I'll have to escort you upstairs because the house is frozen. Detective 4 did escort the complainant upstairs. She advised the complainant that the door had to stay open because the scene was frozen. I'll also add that one of the co-suspects said that he had disposed of some evidence down that toilet earlier. So there's nothing inappropriate about Detective 4 making her leave the door open. She stood outside. She did not seem to inappropriately observe or otherwise do anything untoward towards the complainant. As to allegation number 3, that is intimidation. And the conclusion there was that officers conducted questioning of a minor through intimidating tactics aimed to get the minor to waive his Fifth Amendment rights. Sergeant 1 and Detective 1 conducted questioning of the minor suspect in the upstairs portion of the house, while the other suspects and the other officers were all downstairs. So they questioned him away from other suspects and without a guardian present. Body camera footage shows Sergeant 1 asking the juvenile how old he was, to which the juvenile responded he was 15. Body camera footage shows Sergeant 1 was also personally aware that the juvenile's grandmother was outside, that she had requested to come into the residence numerous times, and that she had specifically requested to be present for any questioning. During the questioning of the juvenile by Sergeant 1 and Detective 1, the juvenile makes multiple attempts to leave and rejoin his brothers downstairs. Each time he attempts to leave, Sergeant 1 orders him to return, stating, you can, quote, you can think up here, you ain't going downstairs. And later, we're not going down there until you talk to us about that gun, end quote. Line of questioning conducted by Sergeant 1 and Detective 1 can be fairly characterized as high pressure. Sergeant 1 essentially berates the juvenile, saying, quote, all right, go downstairs, we're gonna have to take everybody to jail. If it, in reference to the firearm that was recovered, if it's yours, take it. If it's yours, take it. If it's yours, take it if it is. As the minor begins to go downstairs and he says to the sergeant, quote, you said it, the sergeant continues telling him, look at me, turn around. If it's your gun, it's your gun. Quit bullshitting. It is what it is. If it's your gun, it's your gun. Juvenile turns and begins back down the stairs, at which point the sergeant again tells him, hold on, look at me, is it your gun or not? This aggressive line of questioning ultimately leads to the juvenile stating that the gun is his. Even at that point in the interrogation, Sergeant 1 and Detective 1 begin a second round of high-pressure questioning around whether or not the juvenile is involved in gang activity. Detective 1 asks the juvenile if he is a member of 9-8, which is a subset of the 9-8 Mafia Crips, stating, I know you're 9-8. When the juvenile denies being a member, Sergeant 1 asks him, who's a 9-8? Who's a 9-8 that we can call and say that you ain't claiming if somebody asks you what you are? When Sergeant 1 makes this statement, the juvenile is handcuffed with his back to the wall with a staircase going down on one side of him, Sergeant 1 in front of him, and Detective 1 immediately to his right. This question can be reasonably understood as Sergeant 1 implying that he will contact members of 9-8 to let them know the juvenile is denying membership in the gang. This threat implies to the juvenile that he will face violent retribution for his denial being a member of 9-8, and it is intimidating and coercive in nature, especially when directed at a minor. When the juvenile finally caves and states he is a member of 9-8, Sergeant 1 continuously calls him a, quote, wannabe, and continues to insult him. The line of questioning from Sergeant 1 and Detective 1 was intimidating, continuously veiled with threats, and aggressive. Detective 4 was present, but is only part of this questioning for a few seconds, and her questions and involvement did not give rise to the same level of concern. The last category of complaint, is in relation to that interrogation. The allegation was obstruction of rights, to wit, the custodial interrogation of a juvenile. Custodial interrogations of juvenile are governed by MMPD policy 15.30.040 subsection B. And there are a number of factors officers are to consider when they're basically to determine whether a juvenile can knowingly waive their Miranda rights and participate. Those factors include the juvenile's age, surrounding circumstances, including but not limited to the juvenile's experience, education, and intelligence, their capacity to understand the Miranda warnings, their familiarity with the Miranda warnings, whether the child is suffering from any injuries or pain, the duration of questioning, time of day, length of their confinement, whether the child is handcuffed, whether the child was refused access to a bathroom, food, or water, any intoxication, mental illness, and significantly, the presence of a parent or guardian or interested adult, and finally, whether police prevented a concerned adult from speaking with the child, which, according to MMPD policy, is a significant factor. The officer's conduct showed clear and multiple violations of this policy. Body-worn camera shows Detective 2 reading Miranda warnings to the minor and his two adult co-defendants. Sergeant 1 and Detective 1 both acknowledged that a Form 266 rights waiver, which is required by the policy, which basically is just the juvenile signing saying they understand their rights. The officers acknowledged that was not completed. The officers had knowledge that the juvenile was 15 years old and a minor. The officers had knowledge, both direct and indirect, that the juvenile had been arrested before and had been Mirandized before. And those facts were relied upon by the officers, but were given essentially too much weight. None of the officers stated whether they had any knowledge of the juvenile's level of education, ability to read or write, or whether he suffered from any cognitive or psychiatric issues. The other factors that we looked at as weighing heavily against the juvenile's waiver of his rights being voluntary 1, he was not accompanied by a parent or guardian. 2, he was handcuffed. 3, he was not told how long the duration of questioning would be, and was repeatedly told that he would be transported with the other 2 adult co-suspects downtown for further questioning. 4, the officers did not allow the complainant, who was the grandmother, to speak with the juvenile, which is the most troubling factor. The complainant told officers several times she wanted to speak with her grandkids and was told that she could only enter the house if she was handcuffed. Not only is this a blatant denial of access to a parent or guardian by the juvenile, it is coercive in nature. And Sergeant 1's actions disallowing complainant to talk to or be present with the juvenile during the interrogation was a clear violation of policy. Furthermore, Detectives 2 and 3, during their interviews with MNCO, both claimed that their questioning of the juvenile was not, in fact, questioning for Miranda purposes because it did not pertain to the stolen Honda Pilot. These statements were inaccurate and do not reflect what is portrayed in the body-worn camera. Both Detectives 2 and 3 posed questions about the Honda Pilot directly to the juvenile. Sergeant 1 and Detective 3 additionally claimed that their questions were not questioning, but only a prelude to the 3 suspects being questioned formally by the homicide unit. However, whether or not the officers intended to use the information is irrelevant to both the Miranda analysis and the MNPD interrogation policy. Any questions regarding the gun or the Honda Pilot were relevant to investigations of the 2 shootings and could implicate a juvenile in violent offenses. The officers' actions were outside the policy and obstructed the juvenile's right to counsel and his right against self-incrimination. Last but not least, deficient or inefficient performance of duties. This pertained specifically to statements made by the officers during their interviews with MNCO. Sergeant 1, Detective 2, and Detective 3 all expressed total ignorance of the MNPD policy governing custodial interrogation of juveniles, as in they all said they did not know that it existed. Detective 1 did not state the same, but his failure to properly apply the policy evidences the same level of ignorance. What is troubling about this, in addition to just it being troubling generally, is that not only were these officers apparently unaware of this policy on July 12, 2021, but they were apparently still unaware of it up to the time of their interviews in the spring or summer of 2023. And so that was deficient performance, with the asterisk next to Sergeant 1, that there was an additional failure to supervise on his part as the senior officer. So I know that was very long. I'll get through the conclusions quickly. By preponderance of the evidence, the allegations of an unlawful search, as opposed to all the officers, were unsustained. Allegation of obstruction of rights by way of an improper custodial interrogation as against Sergeant 1, Detective 2, and Detective 3 were sustained. That same allegation as against Detective 4 was not sustained. As to discourtesy, the allegation was sustained against Sergeant 1, but not against the other officers. As to intimidation, that allegation was sustained as to Sergeant 1 and Detective 1. As to Detective 2, 3, 4, and 5, it was not sustained. And finally, in terms of deficient performance of duty, the allegation was sustained as against Sergeant, or our recommendation is the allegation be sustained against Sergeant 1, Detective 2, Detective 3, and Detective 1, Detective 2, and Detective 3. The allegation of deficient performance as against Detective 4 and 5 were not sustained. And I can jump right into discipline, or should I wait on that? Okay. In terms of recommended action as against Sergeant 1, I don't believe any of these officers had. Sergeant 1 did not have any relevant disciplinary violations. Therefore, the executive director recommends 10 days suspended for obstruction of rights by way of custodial interrogation, formal counseling for the violation of discourtesy, 4 days suspension for intimidation, and 2 days suspension for deficient performance of duties. As against Detective 1, the executive director recommends 10 days suspension for obstruction of rights by way of custodial interrogation, formal counseling for discourtesy, 4 days suspension for intimidation, and 2 days suspension for deficient performance of duties. As to Detective 2, the executive director recommends 10 days suspension for obstruction of rights by way of custodial interrogation of juvenile, formal counseling for deficient performance of duties. Detective 3, the executive director recommends 10 days suspension for obstruction of rights by way of custodial interrogation of juveniles, formal counseling for deficient performance of duties. For Detective 4, the executive director recommends 10 days suspension for obstruction of rights by way of custodial interrogation of juveniles, formal counseling for deficient performance. And Detective 5 had no sustained violations and therefore no recommended action. That concludes that PRR.
All right, thank you, AD Kiley. Comments, questions from the board? Member Goddard.
Just a quick clarifying question. Are the suspensions to run concurrently or successively?
My understanding from Attorney Yoon is that policy violations have to run consecutively.
Okay.
That anything that is anything that the chief sustains would have to be run consecutive.
Okay. I just throw up for your consideration whether you just clearly state that in the PRR.
Yeah, that's a good idea.
Member Brown.
I noticed in the report of records for Detective 2 and Detective 3, it said not provided. Was there some particular problem that why we didn't get there?
Yes. So the disciplinary records, the personnel files for those officers were not requested until after July 1, and so those are apparently being denied.
Is the criminal case involving the two adults and the one juvenile, have they been disposed of? Or?
Yes and no. So the juvenile in this case was later killed by his, I want to be careful because of juvenile information, he was later murdered by one of the other co-defendants about 2 months later. So the 15-year-old is now deceased. The 23-year-old took a lengthy plea to that charge, and then the second co-defendant, I believe, is out. He had some criminal cases that are all done now. Okay. So and the other guy's incarcerated.
Yeah, and as I understand it, when part of their protective sweep, they did find the gun in the couch where they later placed the defendants.
Yeah, and I'm sorry, there are a lot of facts to juggle. So
you did an excellent job in summarizing.
Essentially the officers arrive, they knock on the door, they order them out. So the three suspects come out voluntarily. At that point, they are handcuffed, temporarily detained outside the house for probably 5-10 minutes. And then the officers bring them back inside. That is essentially because they're waiting on transport vehicles, but then there are a couple of reasons. But so when they bring them back in, there is actually case law that says if the suspect is moving through the area where you're doing the sweep, you can search under areas where they would be seated, and that law is cited in the report. So when they bring the three of them back in, they look under the living room sofas. In our determination, because the probable cause that there were weapons involved was very strong, and in fact, two firearms were ultimately recovered. One as part of the protective sweep, the extended protective sweep, and then a second one was recovered from an upstairs closet along with some body armor later in the evening when the house was properly searched pursuant to the search warrant. So while the officers did look under the couch and recover one firearm there, we determined that was still properly done within the ambit of the protective sweep.
You'd be an idiot to set somebody in a couch without looking at it first.
Right, and that's why I think that carve-out has been recognized by the courts.
Can I ask a question, or just a clarifying question for people to know? Were the guns that they found, were either of the juveniles or adults charged with a homicide connected to any of those shootings that you are aware of?
To my knowledge, no. But I wouldn't swear to that because I don't have their full criminal histories, especially with we were told by the detectives that the juvenile, I believe, was charged with the handgun. He did claim possession of the handgun and was also questioned about the gun by the officers, essentially to determine, was he just claiming it for his co-defendant, or did he actually know the gun? And he gave a description of the weapon. So he was charged with that eventually, but I don't think any of them were ever charged in the shootings.
Let me ask a question, A.D. Kiley. So back to your interview with Detective 2, when he stated that the minor and his two adult co-suspects were Mirandized. You said that something was inaudible when they asked the juvenile. Can you talk about that?
So essentially you're in a living room, a small living room in MDHA housing. You have two detectives sitting at one end, and then you have the three co-suspects sitting on couches. Two of them are together and then one sitting over here. And so the sergeant comes in and he directs the detectives to Mirandize them. I think Detective 2 asks, separately or all together, and Sergeant says all together. Detective 2 then takes out his phone, where he has a Miranda card as the wallpaper on his phone, and he reads them their rights all together. Then he goes around and he says, suspect 1, do you understand that? And you hear the adult suspect say yes, and then he same thing to the juvenile, do you understand? Or, do you waive your rights? It's all very quick. And the juvenile, it's hard to, and Ms. Mansfield's seen these videos too, it's often hard to hear what people are saying on body cam if they're a distance away, and also the juvenile is pretty soft-spoken, so I could not hear or see whether he nods or says yes. It's not clear from the body cam what his response is, and that goes to the problem of them not doing the waivers, is that even a written waiver in these instances wouldn't have cured any of this, but at least then you would have it in writing saying that this child heard and understood his rights. It's hard to tell whether that's the case from the video. The officers from their side, they say they're very familiar with him and that he'd been arrested, Mirandized before, and that none of this should have been new to him, but I'd stop it there.
Sounds presidential.
And if I was going to say, because we reviewed the body camera footage as well, and it isn't, you can't really make it out, but just as a reminder, even if he did say yes, there's still an issue that the fact that he's a juvenile, and that list of factors that are listed in here should have been considered, that even if he's saying yes, does he really understand what he's, agreeing to? Again, the fact that he's sitting there with his two adult co-defendants is another factor, that he doesn't have an adult there. Again, that he wasn't given the form or the card to sign and write is also an issue.
Member Holloway.
Listening to this and reading over the reports and stuff, it seemed like they had enough officers to handle that case just a little bit different. When they brought them outside, they never should let them go back inside. Then they should have separated the three. Secondly, the juvenile should have had some kind of legal guardian. The other guy might have been old enough, but that wasn't his legal guardian. Mm-hmm. So they made a lot of mistakes on that. And they should have just sealed off the place until they got the search warrant. Because if they had proper cause to know these are the suspects, that's where they are, and probably the gun was at this location. You got the suspect, you separate them, seal it off, get your search warrant, and then go through the process. And also, this advising this lady about if she went in, they would have to handcuff. Well, you handcuff, that's detain a person and not allowing them free to leave. So they made a lot of errors on that, I've been gone 10 years, but my goodness, I don't think I would have gone through that process.
What's so troubling is that, and I want to go back to the inaudibility of the juvenile. Regardless, it was wrong, right? They had no business doing that. But for the body cam footage to not provide a clear, audible response, regarding the juvenile being Mirandized, which we know that it shouldn't have happened that way anyway, is still troubling. And I would like to really kind of bring up the point where, and this, we may save this for a different time, but if the videos have been edited in some kind of way, I just don't have the confidence that to say that they didn't, because I've reviewed body-worn camera footage and there were edits to it. But I do want to make sure that we understand that everybody else's yes to understanding their Miranda rights were clearly heard, with the exception of the juvenile. Is that what this report is saying?
Yes, I believe that is so. You can hear the other two pretty audibly, and they're both over, the age of 18 as well.
And for clarity's sake, did you say the sergeant didn't know the policy for juvenile?
That is what he stated during his interview. I pretty much all of them stated that, I think, except Detective 1 is the only one who didn't say that explicitly. And so two things about that. One, just to jump back to your point about body cams, because this was, I can say this doesn't, these were Titans officers, so they are under SID. Titans and SID do have their own standard operating procedures. They have a different, not an entirely different set of rules, but they are granted exceptions to the body cam policy, which allow them to turn their body cams off if they are doing things that are determined to be sensitive, like interviewing interviewing a confidential informant or discussing things about the investigation that they don't want on body cam. They are allowed to do that. I would say, however, that there are a lot of body cam deactivations in this case, and it's not something I think we can really talk about as a policy violation, because they're allowed to do that, but it is not always clear why cameras are being turned on and off. But the second, what was your second point that I'm trying to remember now, was...
The sergeant didn't know the policy.
Right, and so that is troubling, because again, this case is from 2 years ago, and when they came in this spring, they still didn't know it, and multiple of those officers, I believe, were on the juvenile task force. So if you're doing that previously, when the juvenile task force existed, but if you're doing that and you're doing gang intelligence work, I don't want to opine too much, but I would guess that they have a fair amount of contact with juveniles, especially if you're investigating gangs, gathering gang intelligence. And part of what's troubling to me about this is that their unfamiliarity with the policy. The other thing that's troubling about this is asking 15-year-olds questions about gang affiliation, to me, is inherently dangerous. And one of the sergeants said during his interview, that we were trying to talk to one of the adult suspects as, and try to get him to work, be an informant. We couldn't do that with the juvenile. But that doesn't really square with bringing a kid upstairs and asking him aggressively about gang affiliations. There is some stuff in there too where they're throwing around names, street names, which, again, you're getting into an area where you're asking a child to identify people who are involved in criminal activity, I think is very concerning. And so they may not be using them as informants per se, but that is troubling.
And I just want to say, and to piggyback on what A.D. Kiley said, 3 months later, this child is murdered by one of those same co-defendants. And so talking to juveniles about gang affiliation and involvement in front of other people puts their lives in jeopardy. I don't know if the death was related to that. I'm just saying that in July, this happened, in October, he was murdered.
Which is very problematic if we're talking about police officers threatening or intimidating youth regarding gang violence. Member Brown.
If there's not other discussion, I would make a motion that we approve the director's recommendation with one addition, that the police department do appropriate training to ensure that the officers are aware of the juvenile requirements. I think for this many officers, including a sergeant, to say they're not aware of a policy dealing with a very sensitive matter, I mean, the result of that policy violation, had this case gone to trial, could well have jeopardized the prosecution. And so I would add that we adopted with the additional recommendation that the police department conduct appropriate training for their officers on questioning of juveniles. So I would make that as a motion.
Thank you. I would second it. All right. All in favor of the motion of accepting Director Fisher's recommendations with the inclusion of recommended training for all parties involved, Sergeant 1 and Detective 2, Detective 3 as well. Vote with the sign of aye.
My motion was
All of them.
for all police officers, not just these.
Oh, all police officers in MNPD. Okay? All in,
We've already got counseling for the officers, so that'd be part of our counseling, but.
yeah, formal
This to me
recommendation.
seems to be a failure of training.
Where a sergeant is unaware of a policy. All right, we're all MNPD. All in favor say aye.
Aye.
Motion is
All
carried.
right, thank you.
You sure, Sarah?
I am sure you're good. Thank you.
Okay.
All right, and just really quickly to that point before we close this one out, I was going to say to Judge Brown's point, and for the record, every one of these officers that I interviewed expressed what I think was very sincere concern for the child, and I think that's where the training piece is so important. Is that, I think it's just that I think they do need to be trained about what is actually helpful, because I think there's some mismatch about how some of that shakes out. Anyway, the second report, which will be much shorter, is CC 2022053. On October 5th, 2022, complainant reported to Metro Nashville Community Oversight that 3 employees of MNPD had made false statements to her related to a crash report. On Wednesday, make sure I'm in the right place. I'm going to jump ahead. So on September 21st, 2022, the complainant visited the Kroger located at 61 East Thompson Lane. She told MNCO that as she was backing out of her parking space, her vehicle bumped into another vehicle. Complainant stated both her and the other driver exited their vehicles and agreed there was no damage to either car, and they both left. On the next morning, September 22nd, 2022, the complainant was leaving her house to drive her kids to school, and her car was not at her residence. She called MNPD and reported her car as stolen. Later that week, MNPD informed the complainant that her car had been impounded by the police. On September 24th, the complainant spoke to Officer 2 and told Officer 2 that she'd been driving her vehicle at the time of the accident, had talked to the other driver to confirm that there was no damage, and had then left the scene. Officer 2 put this information within a supplemental hit-and-run report. Officer 2 stated in his MNCO interview that he took complainant's statement and information and then subsequently released the vehicle back to her. In an interview with MNCO, Officer 1 stated that he was dispatched to a residence for a man who wanted to report a vehicle accident. Officer 1 confirmed that he did not go to the scene of the accident, but rather was dispatched to the man's residence. That was because the man said that he had called dispatch from the accident scene. Dispatch had told him to use an online portal to use the crash reporting website. The website had not worked for him, and so then he called from his home and requested that an officer come there to take the report. Body-worn camera footage shows Officer 1 viewing the alleged victim's vehicle, taking a photograph of the damage on his phone, obtaining the alleged victim's information. The alleged victim also supplied Officer 1 with the license plate number for the other vehicle, which turned out to be complainant's. The crash report prepared by Officer 1 states in the narrative section that when vehicle 1, the narrative section states that the vehicle 1 driver stated that when vehicle 2 struck him, it fled the scene, and that vehicle 2's driver fled the scene, and that the officer did not speak with the driver of vehicle 2. Officer 1 stated in his interview with MNCO that he asked other officers to look for the complainant's vehicle at the listed address. Officer 3 then went to the complainant's address at 1:09 a.m. on September the 22nd, located the vehicle, confirmed that it matched the tag numbers. Officer 3 then towed the complainant's vehicle. He did not notify the complainant that her vehicle was being towed. Officer 3 stated, quote, "We're not required to let people know when we're towing it if it's been involved in a hit and run," end quote. In his interview with MNCO, Officer 1 also stated that he did not believe there was a standard operating procedure to contact the owner of a vehicle before towing it. Officer 2 stated in his interview that he reached out to the alleged victim of the hit and run and to see if he wanted to take legal action, but that person never made contact, which is part of what led Officer 2 to releasing the complainant. Okay. In terms of the discussion, we looked at this first as an allegation of honesty and truthfulness. The complainant alleged that Officer 1 made a false statement in his crash report when he said that vehicle 2 fled the scene. Although statements may not be accurate as to what actually happened, those statements were accurate based off of the statements that were given to Officer 1 by the alleged victim. Those statements were recorded on Officer 1's body cam and viewed by MNCO staff. Therefore, the statements in the crash report were not false or untruthful within the meaning of the policy, as they accurately recorded statements from the victim. Additionally, because the report made clear that the officer had not spoken with the driver of vehicle 2, we do not feel those were misleading. The second allegation was deficient or inefficient performance of duties. We found that Officer 1 was deficient in the performance of his duties by ordering the impoundment of the complainant's vehicle without probable cause or without justification to preserve evidence, and that he did so without adequately investigating readily available evidence that was material to the probable cause determination. Impoundment is proper under MNPD policy if the officer had sufficient probable cause that the vehicle was involved in a crime, or if the impoundment was justified under the circumstances to collect or preserve evidence, or if the impoundment was otherwise absolutely necessary to expedite an investigative action, and none of those applied to this situation. Officer 1 appears to have limited his investigation entirely to his discussion with the alleged victim. The crime at issue was leaving the scene of an accident, which requires drivers to give their name, address, and registration number to the other driver or their driver's license. Officer 1 did competently collect that information from the alleged victim. He photographed the damage and he collected that person's personal information, which was all good, but he appeared to stop his investigation there. Officer 1 did not go to the location of the accident, the Kroger parking lot. He did not inquire if there was surveillance footage of the accident. The MNPD policy relevantly stresses the importance of collecting crash data at the scene and directs that officers, quote, shall collect and preserve evidence. Officer 1 furthermore stated that he only attempted to contact the complainant after he had ordered the car to be impounded. The MNPD policy 18.20.030 directs that all major traffic crashes, which explicitly includes hit and runs, quote, shall be investigated and documented using the Titan eCrash report, which includes fields for driver information. Other sections of that policy similarly direct officers to obtain all the relevant information about the drivers. Officer 1 failed to follow this policy by failing to make any attempts to contact or interview the complainant prior to impounding her vehicle. Even if Officer 1 had sufficient probable cause to impound the car, MNPD 6.20.030B additionally requires that the impoundment be justified, quote, to collect or preserve evidence of the crime. Officer 2 told MNCO in his interview that there is generally no examination of impounded vehicles beyond taking an inventory of what's inside and noting any damage. There is no evidence that any documentation of damage was recorded of the complainant's vehicle. Furthermore, there's no indication that the vehicle was needed as evidence of the hit and run, and so impoundment was not authorized. Finally, there was no evidence showing that it was, quote, absolutely necessary. The investigation by Officer 1 was deficient in the documentation of the accident. No video footage. So that's as to Officer 1. As to Officer 2, Officer 2 relied in good faith on Officer 1's account and had a good faith belief that there was probable cause to impound the vehicle, and Officer 2 was also responsive to the complainant's inquiries. So, to conclusions, by the preponderance of the evidence, the Executive Director concludes the allegation of honesty and truthfulness as against Officer 1 was not sustained. The allegation of deficient or inefficient performance of duties as against Officer 1 was sustained. The allegations of deficient or inefficient performance of duties as against Officers 2 and 3 were not sustained. In terms of recommended action, review of Officer 1's disciplinary file shows no relevant disciplinary violations within the retention period. The Executive Director recommends 2 days suspension for deficient performance of duties as a Category E offense. As to Officers 2 and 3, there were no sustained violations and therefore no recommended action.
Questions or comments? Member Brown?
Yeah, I'm sort of torn by this one. I mean, technically, Officer 1 had a statement from a witness that there was a hit and run. He has a license plate which identifies the vehicle of the second driver, and he apparently, I take it the photograph does show some damage to his car.
There were photographs taken of the vehicle 1, the alleged victim's vehicle. From what we were told and what we saw, there was no documentation at all as of the second vehicle. And if I'm wrong about that, I'm happy to be corrected, but we didn't see anything that because basically the complainant's car was impounded at 1 a.m.
Yeah.
It was taken to the impound lot. When we interviewed the officer who was overseeing the impound, and I was there for that interview, he said, you know, once it goes into impound, they just keep it in impound. So when they tow it in, there should be an inventory search done, but after that, it just sits there. So if the detective comes to photograph it or something, then it gets photographed, but it doesn't seem like anything was documented as to the complainant's car.
Yeah, I mean, very often, in my experience, the inventories will note any damage to protect the impound lot from being accused of doing damage. I was talking about the photographs of the alleged victim's car.
Yes.
They did show some damage.
Yes. From my recollection, they look at the back bumper and he says there's some small scratches. You can't really see them on the body cam, but you can see the officer photographing them and you can hear them saying, oh yeah, there they are. So from my understanding from the video, I think it was some scuffs and light scratching to the bumper. It wasn't.
Minimal damage at best.
Yes.
Okay.
But to a nice car.
Yeah, I mean, it would seem from a purely legal standpoint that if he had presented what he had to a magistrate, he could probably have gotten a warrant. On the other hand, I'm bothered by the fact that, you know, when you tow a car, it ends up with quite a bit of expense for the victim. And sometimes insurance companies insist there be a police report before they'll consider a claim. So the victim may well have decided to file a police report because he was going to have some sort of insurance claim, but
I also want to add, I wasn't sure, we talked about whether or not she incurred any expenses for the impound. I thought that you had said something to me about that. So could you just,
We'll need to look really quickly because I don't remember. I know they released it to her promptly once she sort of explained the circumstance that Officer 2 then contacted the alleged victims. But I do not know if she was reimbursed, but I can figure that out pretty quickly. I think I have that.
While you're looking for that information, A.D. Kiley, Member Witzel.
Yeah, I guess my question would be for AD Kylie, so I don't know if you can multitask.
Sure.
Maybe someone else can answer this question. I'm curious to know, it was stated that when a car is involved in a hit and run, it's not, they're not required to identify the person's car who they're towing. Not to identify, I meant to notify.
That's correct.
So what is the process if it wasn't a hit and run? Do they call? Would they have knocked on the person's door? How would that work? Because I'm interested in knowing what would have been the way they contacted that person.
I cannot answer that question off the top of my head. I'd have to look at the policy. I know that for hit and run, I think the rationale is basically, well, you fled, right? And so I think legally or logically, that's how they get there. But I think with other instances, like when you have an abandoned vehicle, they leave the sticker on it, they leave notice on it. So I'd have to look, but.
Okay, thank you.
Member Holloway?
Yes, the license plate that the complainant gave to the officer, and they did a registration check on it to determine where the suspect lived was a good address. Mm-hmm. So, from what I could really tell, whoever went to that location should have notified the first off that the car is at this address. It does belong to this resident. And also, he should have talked to someone about that vehicle instead of them people had to wake up and find their car gone.
Yes.
And would have saved a whole lot of headache and pain, because sometimes when you get in an accident like that and you don't feel comfortable after the person has left, you said, I should have got a report made. So you call the police, and then trying to cover yourself, trying to get it taken care of, the damage, So always been advised people always get a report made. And then if you decide to pursue it further, you can, but at least you got a report on file saying this happened at this location and time, and these are the parties involved. So I find fault in them not talking to the second person that the vehicle belongs to instead of towing them, and they wake up and they say the car was stolen. That's very frightening. You want to know where my car, and all that could have been saved. Just simple knocking on the door, saying, is this your vehicle? Do you have registration? Do you have ID? And then tell them why you were there. And tell them about you part of an investigation of an accident, and then maybe they can verify to them what they're worried on. Basically, you confirm on one person,
right?
Respond, and should have taken all parties that are involved as you possibly can.
I think that's a good point. I'd just add to the other kind of weird wrinkle with this is that if you're impounding the car because it's evidence of a crime, and then you go to the person's house where that the registered owner lives, why wouldn't you talk to them to charge them and or cite them or do whatever? Because there's a crime in play, right? The allegation is you left the scene of an accident, which is the closest thing that is our hit and run statute here. So if you're going to charge the person with that, it is odd to me that you would not just knock on the door and say, I'm giving you a criminal citation, rather than just taking their car and not telling them.
Well, first of all, you got to verify if it is a crime.
That's right.
Right.
That's number one. And that's the reason why you need to talk to both parties, to find out each party's story, so you can determine if there's probable cause to make an arrest.
Right.
Yeah, and I think the most troubling part of it is that the investigation stopped with the alleged victim, right? And it wasn't the crime. If there was a crime, it wasn't investigated. The officer did not go back to the scene of the crime and the location, ask for any kind of video footage. Is that correct? And
right.
It just stopped at one person's statement. Did you get a sense, A.D. Kylie, of, and I know we have a finding of deficient and inefficient performance of duties, but why would a officer stop at an alleged victim's complaint and not investigate further. That's pretty troubling.
I have a partial answer for that, which is, I think, also kind of mitigates a little bit of this, was that the wreck happened in one zone and the gentleman lived in another. So the accident happens at the Kroger, which is within one precinct. So the alleged victim calls from there, dispatch tells him, go use the website. So he says, okay. He goes home now to a different precinct, which I want to say is South. So let's say he goes to South Precinct. He gets home and tries to use the website, and the website tells him you cannot use the website for hit and runs, I think. So then he calls. So now he's in a different precinct, and they send him an officer from that precinct who comes to the house and interviews him. I think that what happened was that Officer 1 basically was like, well, the wreck happened in a different area, and I don't want to read his mind, but he did not drive all the way over there to go get the surveillance footage. And I think that's part of what happened here, is that you have different officers. So then when Officer 3 is out on his patrol and he finds the car, all the information that he has is just, oh, this car was involved in a hit and run. So he just gets it towed. So there does seem like a chain of not super thorough work that leads to this, but that initial wrinkle, because I had the same thought, I was like, why didn't he? But I think that's part of it, was that it was, when officers are on patrol, they're dealing with the stuff that's in their precinct. So I think that may have been a part of the problem. It doesn't change anything under the policy. The policy doesn't care about what precinct you are. The policy basically says the responding officer is the one who's responsible. So that's why that all still comes back to Officer 1, I think, in our reading, was that wherever it took place, either under the policy, he either had to finish that out, or I guess could have handed it off to somebody else who was going to do that. But yeah, I think he basically took one side of the story and ran with it.
Did you ever find the answer to if the victim was?
No, I do not know, and I can look in the notes and see if we asked Officer 2 about that, because that's who we would have asked. But I cannot tell you.
I think that you said that they did not charge, but you wasn't 100% sure. I mean, it doesn't make a huge difference here, but I mean, it just would be
Yeah, no, I'd like to know.
helpful if they did not charge her for her vehicle.
How it was remedied.
Yeah.
Member Holloway, did you have a comment?
The simple answer to the whole process, they did not communicate like they should have. We got more than technology in these vehicles where you can talk, and then the average officer got cell phone as well. And the communication just didn't go down the chain like it should have.
Member Brown? You don't want to do it? All right. All right. So any further discussion? Do we have a motion on the floor? Anybody?
Thought we had a motion second.
No, I think that was the other one. Yeah.
Move we accept the ordinance presented by the executive director.
All right. All in favor? Motion carries. All right. Now we will move on to the use of force policy advisory report and update. Mr. Gavin Crow-Williamson, please come forth.
All right. Good evening, board members. Good to be with you again talking about use of force. This report is basically, I'm going to start with an update from where we are last month. Since last month, when you received a draft, we have finalized a draft implementing feedback from multiple board members, from other staff, and from MNPD. Next slide, Gracie. There are some outstanding points that we're working through with MNPD that we expect to have incorporated for the next version. But something I want to be very clear about at the top is that this is still a draft report. And in my opinion, we are approaching the most important phase of our draft policy process, which is community and stakeholder feedback. I'm not going to read this whole chunk of rules that I've posted up there, but the gist of it is that before the board votes to adopt a PAR, the report must be considered on 2 different agendas, and there's going to be a public comment meeting in the middle of that. At that first meeting, which is tonight, we're going to present and explain the draft report, how it was developed, and the key issues of the report. And the board can discuss but not vote to adopt that meeting tonight, or excuse me, that report tonight. And unless the draft at this point is withdrawn by the director, it's going to proceed, and the chair will appoint a 1-person board committee to solicit public comment and conduct a public forum. So just to put it in context of where we are, there's still a lot of opportunity for board feedback, for community feedback, and for stakeholder feedback. Next slide. So just to put us in context a little bit, I think it's important to remember that the COB exists because of MNPD's use of force and the community's reaction to that force. Force is not a particularly frequent event, but it is really important and very powerful for the people who experience it. Looking nationally, less than 2% of police-civilian contacts involve the threat or the use of force, and about 4% of arrests involve more force than necessary to handcuff a compliant subject. And so I think those low rates kind of mask the high number of actual use of force incidents that occur across the country. If we conservatively assume that force is used in about 1% of encounters, that's 600,000 uses of force across the U.S. And the consequences of exposure to excessive force are serious. In addition to the force itself, there's levels of raised anger and anxiety, lower levels of trust and approval in the police. And of course, there's a monetary perspective as well. High-profile police misconduct lawsuits can cost taxpayers large sums of money every year. Research literature has also highlighted that the use of force can be disparate in many contexts. Black, Indigenous, and people of color are more likely than white people to have force used against them, to be killed during police encounters, and to be unarmed during fatal police shootings. There has been additional research that shows that white officers in predominantly black neighborhoods have fired their firearms about 5 times as frequently as black officers in the same neighborhoods for similar calls. There's research that shows that the Chicago police were more likely to stop, use force, and use severe force against black people even after taking crime levels and subject actions into account. And about half of LGBT survivors of violence who interacted with the police reported police misconduct like unjustified arrest, excessive force, or entrapment. There's also interesting literature on the differential treatment for black youth, which shows that in general, people perceive black boys as older, less innocent, more responsible for their actions, and even potentially as more appropriate targets for police violence. And on the flip side, people have been shown to believe that black girls need less nurturing, protection, support, and comfort while being more independent and knowing more about adult topics. And all that together really contributes to this increased adultification of black youth, which has really severe consequences in policing. Black teenagers have been shown to receive more force during police stops than white teenagers, and that effect is especially pronounced for firearm usage. There's also extensive research looking at the relationship between force and resistance levels, but that altogether begs this big question: what can be done to curb these disparities? So to try to answer that large question, we asked a bunch of research questions. How much force is used annually by MNPD? What types of force are being used most frequently? Against whom is force used? Which officers are using force? Where is force concentrated? What's the relationship between resistance and force? And were there any unique trends in 2022 for MNPD's use of force? So we started to answer those questions by simply looking at the volume of force that has been used over the last 5 years. You can see 2 notable spikes in just the number of reported use of force incidents. One is in 2019 when MNPD began tracking firearm displays as a use of force, and another is in 2022 when MNPD began tracking soft empty hand controls that did not lead to injury. So it's important to note those 2 spikes are more reflective of increased tracking than increased force, but the volume of data and the volume of force information we've received over the last 5 years has really increased. really probably not going to be able to see very much on this screen, so I apologize for that. But if you look at the highest reported use of force incident, or in an incident over time, you can see that soft empty hand line shooting up from 2021 to 2022, and a firearm display increase from 2021 to 2022 as well. But those really dominate and kind of clutter this graph. So if you go to the next graph, you can see a little bit more easily, though again, not on this screen, that most force types have sort of declined over the last 5 years, or they've been subsumed by other force classes. So for instance, takedowns and grapples and hands have all been subsumed by soft empty hand control. But the one notable increase here is that taser deployment has increased quite a bit since 2019, and so that's a trend that we're going to be focusing on moving forward. Again, if you exclude soft empty hand control and firearm displays, you can see that there's pretty stable use of force over the last 5 years. There's sort of natural ups and downs. Obviously a slight up in 2022 there, but it's not really clear that that's a pattern as of yet, just something we're keeping an eye on. And a similar thing with soft empty hand control that results in injury. You can see from 2021 to 2022, there's a pretty significant spike, but that's just a 1 year data point, so we'll keep monitoring that as we move forward. I wanted to have a quick note on benchmarking before I go into the next section. What I mean by benchmarking, it's something that's done often in criminology when you compare one kind of data, in this case, use of force data. It's common to benchmark it with other types of law enforcement action, like arrests. And so what we've done is we've benchmarked overall force rates against population, arrest, and suspect data. And this is one of the sections we're working with MNPD on to make sure these benchmarks are accurate and robust as possible. And these analyses that I'm going to present for you in the next couple of slides and that are in the report are here because they exceed those benchmarks. They are happening at rates more than overall force usage. But we have to recognize kind of two simultaneous truths when we think about benchmarking. One is that it is true in Nashville that Black people are the likeliest group of people to be arrested or suspects of crime. And so by the nature of that, they'll naturally have more force used on them. So it's important to have that context. But in addition, we have to consider the disproportionate impact of force has a very real community impact that we're really trying to amplify here. Regardless of how force is used relative to law enforcement tactics, we believe that historical and current over-policing has a really material impact on the lives of those in marginalized communities, and we want to uplift and recognize that and keep that in mind when we're considering all these factors as well. It's not just about other crime metrics, it's about real people and real lived experiences. So you can see just overall, the graph makes pretty clear that as a rate, Black folks see force used against them much higher. That's been true since this data has begun in 2018. And it's especially clear when you compare overall force usage to population percentage. Black folks in Nashville account for just over 60% of the force used by MNPD in 2022, despite only about 27% of the population. That number is a little closer to the percent of arrestees of all crime in Nashville in 2021, which is at 57%. And so that's where some of that benchmarking comes into play. But if you go to the next slide, you can see, and when you start to break it out by certain force types, you can really see the force types where Black folks are much likelier to have force use on them relative even to overall force rates that have been adjusted for other law enforcement metrics. So the very clear example here is that MNPD displayed a firearm against Black subjects 3 times as frequently compared to white subjects, and that exceeds any disproportionality or disparity ratios that were outlined in the report, which suggests firearms are displayed in a particularly disparate way. Same pattern, though less pronounced with soft empty hand control incidents, and you probably can't tell from this graph, but we think that this highlights a really important thing. Since MNPD began tracking soft empty hand control without injury beginning in 2022, the disparity between non-white and white has actually started to increase. So we're going to be monitoring that in coming years. But again, Black subjects had soft empty hand control tactics used against them 1.7 times more frequently than white subjects, which do again pass those disparity and disproportionality indices. And then we start to get to youth, which is, I think, where the patterns really start to emerge, and they become particularly stark. Compared to white youth, black youth are the victims of police force almost 10 times more frequently, and Hispanic youth 1.2 times more frequently. That 10 times for black youth is way beyond the disparity in the disproportionality ratios. And if you continue to break it down by those same force types as earlier, you can see the effect becoming even more stark. Black youth had a firearm pulled on them over 14 times more frequently than white youth, and Hispanic youth 2 times more than white youth, both of which pass those disparity and disproportionality indices. And the same story for soft empty hand control, where black youth have that used against them almost 9 times more frequently compared to white youth. And that is a statistically significant difference, as well as outstripping those ratios. Before I get into this slide, I want to talk a little bit about the context of it. The board brought up on multiple occasions their interest in seeing when, where, and against whom school resource officers are using force. And there was no perfect way for us to get this based on the way that we have data. So this should be viewed as sort of an exploratory or an introductory approach to this problem. So what we did to kind of proxy an answer here is we filtered all school resource officers or anybody who worked in the school resource officer section and linked that to force data. We then filtered subjects of force to those who are children, so 17 years of age or younger. And we restricted the data to 2022 and 2023, since what we have are current duty assignments, to maximize the potential that these school resource officers are using force on youth in that capacity. This is a really imperfect way of approaching this. There's any number of limitations, including the fact that SROs could be using force outside of school on youth, but this was sort of a proxy way to establish this and represents a point of future inquiry, we think. With all those caveats in mind, we can see that from 2022 and 2023, there were 25 different SROs who used force on youth 90 times that were tracked. Of the officers, they were mostly white males, followed by black males, and the youth were almost exclusively black and predominantly female. That you can see it's about 96% of youth were black and about 58% of the youth were female. That's a familiar story from what we've been talking about in terms of black youth with previous information in this report, but it's sort of an interesting flip in terms of male-female. Pretty much all criminology research shows that men are more likely to be the subjects of force, and so it is interesting and a little concerning to us that has flipped in schools. But like I said, this is just a preliminary look. We were not able to establish any sort of causality here. It's just an interesting sort of proxy to begin thinking about this data. Next thing we want to talk about is canines. Canines are not the most frequently documented or used type of force, but they have very serious historical connotations. We've seen across the country, the DOJ, when they were reviewing the Ferguson Police Department, they found that they used canines almost exclusively on black subjects and often excessively. And in Nashville in particular, and the South, I suppose, more broadly, there's a really rich history of civil rights, and specifically the use of dogs to disrupt civil rights efforts across the South. And so this use of force, firearms are intense as well, of course, but the use of canines is really a loaded type of force. It carries a lot of historical and generational trauma with it. So even though it's not used as frequently as some other types of force, we still wanted to bring that conversation. And this figure shows that there is a slight overrepresentation of black subjects as being recipients of force from canines. It's about 4% higher than overall force rates, and that's not a statistically significant difference. But as I said, it's really difficult to represent this historical and often traumatic use of force, so we just wanted to bring light to this. While it does reflect that small raw difference, there's a lot going on here still. When canines are used, it almost always ends in an injury. 79 of the 85 canine incidents led to an injury. And of those 85 usages, 15 were against children, 12 of those 15 being black children. So we again see some of those disparities start to pop up, even if they are sort of small. It's something we wanted the board and the public to be aware of. Okay, this is just a brief foray into officers who used force. Of officers who used force, male officers used force more frequently. White officers were the race that used force most, Asian least, in between that, American Indian or Alaska Native, then Black officers, then Hispanic or Latino officers, then officers of 2 or more races. And when we broke it down by officers who had the highest volume of use of force reports, the top 10%, you can see that on the right there, almost 100% of those officers were male, about 85% were white, and most were officers in either the Community Services Bureau or the Investigative Services Bureau. And I think it's important to call out that the Community Services Bureau is not like a community relations bureau. Community Services Bureau does contain folks who do community relations, but it also contains the precincts themselves. So a lot of the people who are in the Community Services Bureau are patrol officers from any of the given precincts, just so we're all on the same page on that. And then we ran some higher level, multi-level analyses. We used linear regressions in a stepwise way, which means we were introducing one variable at a time. We were trying to predict force levels using resistance levels, subject race, subject age, officer age, subject sex, on-officer sex, all reported by MNPD. We did all the things you need to do for a linear regression model, which include checking for linearity, normality, heteroscedasticity, which is a real word, model fit, and any influential cases. And it's important to note that there was a ton of folks in this data who had no coded levels of resistance, and we'll get into that a little later. But these analyses were run exclusively on subjects who had some level of resistance, which is a limitation of this data, but it's what we had to do, given what we had. And so I'll try to be quick. All models revealed that there is a relationship between resistance and force. No surprise there. Several models showed that of officers who used force, male officers used more force, white officers used more force, and white officers are significantly more likely to injure subjects. Several models also showed that male subjects who resisted had significantly higher levels of force used on them. One model showed that when there are some resistance, white subjects had significantly higher levels of force. And for those whose race is missing, which is really quite a small proportion, there was nonetheless a statistically significant higher amount of force used on them compared to Black, Hispanic, and white people. So that's sort of interesting. Last sort of analytical section here is to think about the space of force. And on this first slide, you can see where force is occurring by police zones, and then by RPAs, which are reporting areas. These are much smaller areas. And while that's kind of interesting, next slide, I think it's important to consider that over the percent of the population that is not white, as well as the percent of the population that's in poverty based on census tracts. And so this shows up so poorly. But these, what are yellow dots, are larger proportionately based on the uses of force, and we can see that use of force does tend to concentrate in non-white and areas that are in poverty. So the last thing I'm going to do, I'm going to read all of the recommendations because I know you all have them in front of you, but I think it's important for anybody who's watching this online or any community members who might be watching this back later to have that information. So our recommendations are as follows. Number 1, MNPD should include all soft empty hand control usages regardless of injury status, firearm displays, taser displays, and accidental discharges in their departmental use of force analyses when there's a subject present, including on their public dashboards. Number 2A, MNPD should revisit and modify its use of force training and reporting mechanisms to include more consistent tracking of resistance levels across all Form 108 types. That includes 108, 108F, 108T, and 108NC, because we learned that for all 108 forms that are not just a regular 108, MNPD is not tracking resistance levels. And so those large number of cases that we had to exclude represented, for the most part, instances from 108Fs, 108Ts, and 108NCs, and that information is just lost aside from being in incident narratives, and we don't think that that's appropriate. So we think that they should update their manual to define all terms that they use on the Form 108s, and the data that's provided to us should be updated to reflect this change. Number 2B, We believe that MMPD should randomly audit instances from 2022 onward in which officers use force and resistance was not tracked or was coded as no resistance. And the purpose of this audit should be to verify that there was no resistance. That can be through body cam review, through force reporting, etc. And if officers are determined to have used a disproportionate level of force, MMPD should take appropriate action. Number 3, MNPD should create a peer review panel where supervisors or peers can anonymously report officers who they believe are involved in an above average number of violent encounters. This panel should be supported by part-time staff who, in addition to serving on the panel, study police community violence and create interventions to combat such violence. Number 4A, MNPD should use a comparative method based on their force and resistance continuums to evaluate when officers are using force that's disproportionate to resistance, even when force levels are low. We believe the establishment of such a method should be done in consultation with MNCO and community input, such that the community perception of force is prioritized in MNPD's assessment of force and resistance. 4B, the comparative method referenced in 4A should be incorporated into MNPD's early intervention system and should flag officers who repeatedly use a level of force disproportionate to resistance. A review of each officer's use of force from the prior year should be included in their annual performance evaluation to identify officers who are involved in a disproportionate number of force incidents or who are frequently using excessive force. Number 5, MNPD should develop use of force policies and training specific to interactions with youth, modeled after best practice policies, and they should include de-escalation, officer presence, communication style, allowed or disallowed uses of force, disparate use of force across race and gender, and other topics as necessary. And we think that such policies must address that force of any kind against youth must be consistent with age, body size, disability status, relative strength, and risk posed by the youth. Number 6, MNPD should electronically notify MNCO staff every time MNPD staff use force in Metro Nashville Public Schools, and such notification should be delivered in a monthly report that includes information including officer name, incident number, incident narrative, school location, subject demographics, type of force used, and the narrative in incident report. Number 7, we believe MNPD should modify its implicit bias training to address the bias officers may have against entire neighborhoods based on the racial and socioeconomic makeup of those neighborhoods. These trainings should include paid representatives and trainers from the Nashville community who can serve as consultants and speak to the histories of their community and the issues they face, and should be precinct and neighborhood specific. Last slide of recommendations anyways. MNPD should train recruits and officers in procedural justice principles, focusing on both internal and external standards, and the training should be standalone, repeated annually, and follow evidence-based standards. Number 9, MNPD should modify its use of force forms to include checkboxes for all de-escalation techniques used by officers, and those should be tracked and analyzed as to how they relate to officer use of force. Number 10, MNPD should modify its de-escalation policy and training to include specific stipulations on procedural justice, which should address active and empathetic listening, nonverbal communication, word choice, and de-escalation techniques that are grounded in procedural justice principles. And finally, we believe MNPD should continue to focus their recruitment on non-white and female candidates until all ranks of the department are staffed with representation at levels that are significantly closer to Nashville's overall demographic makeup. And these are some future studies and future ideas. I'm not going to read through them all, but in general, we view this report as really a jumping off point. This is the beginning of what we think are a number of important future studies, including looking at school resource officers, looking at use of force against members of the LGBTQ community, analyzing settlement costs, and above all, we really want future analyses to prioritize community and stakeholder input, so anything is going to be built on that. So the real last slide is just sort of a reiteration of what was at the beginning. The director can choose at this point to withdraw this report. If she does not, it's going to proceed, and at this meeting, the chair will appoint a one-person board committee to solicit public comment. That committee will then conduct a public forum with the director to receive community input on the draft, and at the August board meeting, the board will hear and take a vote on whether to release an updated report that includes all the information that we receive over the coming month. So that is all I have. I welcome questions and any discussions on where to go.
Any comments, questions, discussion regarding the use of force report? Are we pleased? Member Goddard?
I'll try to be quick. Some of this is more process going forward than this specific report, but I think it's relevant. Our process, as I understand it, I'm probably oversimplifying, is that there is a ton of available data, public data from Metro Police Department. They've got an enormous database. They got a lot of it online. We pull lots and lots of that data. We do lots and lots of statistical analysis, that sort of things like that. We wind up with a report like today that it has a lot of that stuff and good stuff, but also has a number of qualifications. We didn't have this data. This creates uncertainty. I'm not going to list all of it, but over and over we've got that. And a lot of that data is available from the police department or could be made available. And I would hope we could work towards a situation where we could sit down with the police department, plug those data gaps best we can, get the real data. We don't have to agree with it, use the data if we think it's flawed, but at least get more data and try to have fewer holes there when we get to that. Second thing I'm going to say is an example would be the various comparing, ranking by number and comparing use of force to resistance and whether it was okay. And a number's thrown out, a couple of numbers that the use of force was higher than the resistance numbers. I've got a lot of issue with statistically how you just assign individual numbers there, but laying that aside, after that came out, this from discussions I've had with Gavin, we got information from the police department that said a whole lot of these soft empty hand control that didn't result in injuries, they didn't have any data on whether they weren't required to report, don't have data on whether there was resistance or not. Those had been assumed to have resistance, is my understanding. But those numbers were rerun as described. Back up, that came in. But the other thing in the report is the second paragraph is you've got a compressed and separate set of ordinal rankings for it's 1 to 5 and 1 to 5. When those numbers were run without the soft empty hand control that was pulled out, this new data, it was just the opposite. The use of force was significantly lower than the amount of resistance in terms of comparing. If that's something we want in here, I think we need both. But more importantly, I think we need more data and some harder looking at those numbers on stuff like that. A lot of words try to conclude. I think we should try very hard to get all the data we can to plug data gaps and not have assumptions or not have weaknesses in our data on this kind of stuff. I think it would also be helpful to have some sense of how many uses of force, however you want to define that, make it clear what you're defining, we have on average per officer out in the field per year, and how that compares with other larger cities. I may be the only one that cares about that, but that kind of context would be helpful. I don't know what that shows, whether that's good or bad for MNPD, but that would be a helpful piece for me. Thank you.
Member Goddard, can you speak a little bit more about what was the second point that you had regarding?
Soft empty hand control?
Yes.
Yeah, there's a complication. I won't call it a flaw. There's a complication in this, and Gavin, please weigh in here if you disagree, but maybe if you agree, that there are a large number of data points and a large bunch of the graphs got higher in 2022. And that was because for the first time we got reports, data on how many uses of soft empty hand control there were without injury. If there's an injury, they've been required to report, fill out another form. They still do, and they log whether there was resistance or not. For those, I think it was 1,700 maybe that were without resistance, going on 1,800, 2022, something like that. Those are there, and we don't know whether there was resistance or not. So we can either, I don't think we can assume all are without resistance. I don't think we can assume all are with resistance. You either pull them out of the database when you're comparing use of force and amount of resistance, or I think that would be best. I think that's what Gavin did on some of the stuff. I suppose you could say 50-50 maybe, just for lack of a better number, but that's a piece that's there. I agree with the recommendation going forward. We need to have those reports completed to include that data.
Right, and that was one of the recommendations that
Yes.
you made, right?
Yes.
Okay.
And I don't view it as a flaw that as we first jump into this first big report, there's a whole lot of stuff we wish was reported differently, a whole lot of additional data we wish we had. That's how that process necessarily starts, and hopefully we get better from here going forward.
Yeah, and I agree, and I think what Gavin stated was that this was just the beginning, if you will, of the use of force, analyzing, use of force, different uses of force, and then how it correlates with the community story, right? And victim interaction who were at the hands. Particularly, I wanted to bring up the canine use, which is very troubling, of course, and it being used at a high rate. Even though the numbers were small, it was used at a high rate on Black youth. So did you say 13? How many was it? 14 and 12 were Black?
12 of 15.
15, okay. And so when we're looking at this, Member Brown brought up training for all of MNPD on one of the earlier PRRs that we heard, and the recommendation for training on de-escalation when it involves youth. And what's interesting is the use of force with Black female youth, right? And so, when you're looking at information like this, and growing up as a young Black girl before, I wouldn't come out grown. It's very troubling because, it goes back to and is correlated to the use of force and how it breeds mistrust, right, with the police, and sparks up anxiety and anger, right? And so a lot of this data that you have presented is connected with other parts of community and building it and engagement, and organizations that pour resources in communities like we're talking about here in this use of force report, and how that effort can be thwarted by misuse and use of force from the police. So I appreciate this information. Member Brown?
It's a fascinating report, and I was struck by some of the numbers on the school resource officers. Is there any skewing of that data that there aren't resource officers in all the schools? Are they concentrated in one particular area, minority areas, or that as to whether that figure is skewed a little bit, as to, if they have officers in all schools, then I think you can draw more conclusions, but and that may be a different problem as to why aren't they assigned citywide, or are they concentrated in certain areas?
Yeah, that's a very good question for the future. We don't have data in the data set we have on which schools officers are assigned to. I know there's been some reporting done on that, and they're certainly not in all schools, and they are concentrated in some schools. So we'll chase that down. I think that's a really important avenue.
Director Fitcher, go ahead, Member.
To that point, I think all middle school, high schools have an SRO. I know all high schools. I know specifically they do, and I want to say middle school. I think coming up from some reports and news that this coming up school year, the elementary will not, because they said that of the lack of bodies to disperse, more officers. But I did have a question, I think, to look at also. I think to dive in, I think a little bit deeper as a recommendation is to look at the type of crimes that was allegedly that was committed on these use of force. with all the categories, especially with the youth. I would like to see that moving forward. And of course, I would love to see it, to the point to see if, what schools, I talked about this last month, to kind of categorize schools, look at and then I would love, and I can pull in some other, and I know we're going to have a conversation, but I will pull in some other nonprofits and community agencies to kind of cross-reference the lack of resources, the lack of after-school programs, the lack of all those things to see, what's going on in these particular areas where there's high use of force, where there's poverty, and again, I spoke before that I think the city, the next mayor really needs to look at this type of data to look at. You talk about the vision. These are the type of questions that need to be asked during this time, especially election time. But I think a leader will look at this information and say, this is where some things I need to look at to disperse money, disperse resources, and ask these questions. But I definitely appreciate the work. But yeah, I would like to look at what I just mentioned. But I think the types of, I'll just be curious to see the types of crimes that was allegedly saying that they were doing to get those youths. I know in schools, and I say this and I'll be done. I think in the schools, I'll be curious to see were these fights, misconducts, and what. And then there need to be some type of training around how do I restrain those types of things with the use of force. And so, and I know working in juvenile back in the day a little bit, that was a lot of DOC allegedly crimes or what have you that were based upon fights, based upon a lot of fights. And so I think this is some, this is a great start. I think the community needs it. I think the city needs it. And if we dive a little deeper, we can get down to some root problems and really can come up with some solutions. But I definitely appreciate the work. But those are some of the things I would like to see.
Director.
Okay. I wanted to thank you, too, for this report. As I read over this report, it was very sobering for me to see the kind of force that's used in our city. Although it's a preliminary report and there can always be something added to it and there can be additional data, the work that you guys put into this report is amazing. With the very limited resources that you have. And so I just wanted to tell you how much I appreciate the work that you did to produce something for our city so that we can make some corrections. And I would say this while we're talking about that what's important here, as well as what's included in this report, is the recommendations. The recommendations to have the chief of police read these recommendations and implement something that makes our city safer very quickly, immediately. Because I think that any person in leadership and control of this city would want any of these recommendations to be implemented as quickly as possible to ensure that our officers are making certain that they are using de-escalation techniques more so than using use of force. So thank you for your work. I appreciate you.
Member Holloway?
I'd like to thank you for the report also. But just keep in mind, just last year in April, we asked Commander Lara to invite the commander that was in charge of hiring to our board meeting. I told him, I asked in April, and hoping that he would respond at least by June, give him a month in between to get his calendar organized. And this is July 2023. I haven't seen him yet. But basically, it's really about having the police department reflect the community. We just had a class that graduated a few days prior to this meeting, and it's not an indication that they're doing the job that we're looking for. And so My thing is, if you got a commander over that building and he's not getting the job done, he can be replaced or he can take his pension. You know, not I'm in a position to make that a decision, but there need to be some changing. Let them know that, hey, this is something that people will not tolerate. Looking at your stats, they're excellent. I never did look around that much because what I see is something that I've already been familiar with throughout 35 years of policing. And so it's not getting better. It's still escalating. Recording open hand force is a track record, really. You can do several of those, but when you get in the court and they pull your personnel file, they're gonna say you're a violent person, even though you didn't really intentionally hurt nobody, but it's just a hand slap or something like that. And you see all these different incidents been filed against you in your personnel file. So one get to thinking, say, I got all these in my file, I could lose my job. Maybe we'll slow them up, let them think that we need to kind of de-escalate things instead of reacting.
All right, I don't want to belabor this, but I would like to say, Member Holloway has a really good point when we're talking about the department reflecting what the community actually looks like. And I hope we don't come into a situation where, as Mitt Romney did, he said he had binders full of women. I hope we don't have binders full of women and black officers or officers of color, and we're not doing anything about it. And so hopefully the person who does the hiring and recruiting will come now, Member Holloway, even though Commander Lara is not in attendance at this meeting. Gavin, was there anything else you'd like to add?
Nothing else I'd like to add, except that it's your prerogative to assign a one-member board committee to conduct public comment and feedback. We can do that tonight if you want. I defer to you on how to do it, but I did want to say I spoke to Member Wynn last week since I knew he wasn't going to be able to be here, and he did express willingness to be on that committee. Not to say it should be him, but he wanted that message come across. So I defer to you on how exactly that works.
Okay. Director Fitchard, did we hear, and I know you heard from Member Wynn, but what did Member Wynn say? I think it is.
All right, just 1 second. Member Wynn, he wasn't able to make it because of previous engagement, but he did say, let's see what he said about the report.
Mm-hmm.
If you're referring to what I think you are, Director Fitchard, I
Yes.
just forwarded it to you so you have it again at the top of your inbox.
Appreciate that. Thank you. All right. Let me come out of here. Sorry for the delay. I've got 5,000 emails. All right. Did you forward it to me just now?
Within the last 30 seconds, yeah.
Oh, okay. Just read it.
Sure, I can do that too. All right. Board Member Wynn says, job well done. This report demonstrates the seriousness and professionalism of the COB to the police, the public, and should be shared with every oversight board in the country. If I were a supervisor inside the MNPD today, I would treat it with great respect and start to self-assess immediately. He then brings up that he would like to provide some input on the 7th recommendation, which is about bias. And he says, using points made in the IACP resolution on bias or recommendations from the 21st Century Policing Report could add some weight by using law enforcement national standard. Likes to explain bias impact for non-law enforcement readers, and that it should be something that we normalize within the criminal justice system and within policing. So those were his comments.
Okay, and those are comments well received from Member Nguyen. And so what is the protocol for me to
appoint a
appoint,
one-person committee? You just take anyone who wants to volunteer for it, if they want to be on that committee, and then what they would do is just show up at the meeting and be there. Anyone from the board and the public can be there, but they just always like to have one person who is like the chair of that little committee. You can also nominate yourself. It's up to the board to make that decision.
Okay, thank you. And so, remember, you said Member Nguyen did voice that he'd like to lead those efforts, correct?
Well, I asked him, and he said he'd be willing to do it. I don't want to put words in his mouth, but he is, I think he'd be a good pick since he's sort of a nationally recognized expert on this topic and well recognized in the policing community. But
I agree, and with his absence, he is now the chair of the use of. He is of this use of force report, and so tell him that it was my understanding that he wanted to volunteer himself.
I will, and as an aside, I think Reverend Turner brought this up a little bit, but if anybody on the board has any organizations or people that they would like this document to reach, please let me know. I'll send it to them. I'll have as many conversations as I can over the next month. I know Member Nguyen has some, but if any of the rest of you have anybody you want to have eyes on this, please tell me and I'll make it happen.
Okay, thank you. Okay, that's fine. Thank you, Gracie, and thank you, Gavin. You guys, I mean, once again, it was an excellent report. Thank you for your hard work, and thank you for continuing to move this report forward. Okay. All right, new business announcements.
I just have one thing. I had the comment from the complainant in one of the cases, and I meant to do this right after it was read, but we were, for the case that we read that included the juveniles, the complainant who made that call to us, if you would, I'd like to read her comment.
Okay.
All right, I spoke to her on the phone. She could not make it. She said she works at a double shift.
Okay.
All right, she stated that the sergeant and the detective, Sergeant 1 and Detective 4, targeted her family excessively. She stated she felt harassed and was intimidated by both officers. She stated that her grandsons had been exposed and the recipients of police violence by officers, so much so that one of her grandsons had his tooth knocked out, and that she filed a complaint with the Nashville branch of the NAACP for that particular encounter. She stated she did not feel safe reporting this to the police department. She wants the police to be held accountable for their actions because they are not doing their jobs the right way. That's all she said.
Thank you. I don't think this story is over, but I do believe that meaning for oversight and what that looks like in the next coming months. Thank you, everyone. If that was all of the announcements and new business, we have one from Member Witzel.
This is not either one of those, but I feel compelled to share this. This whole, since we talked about the first PRR that involved the juvenile, that's just been really sitting with me for the rest of the meeting, and to find out that, for him to no longer be here, I think it's just punctuates even more the importance of what we do. And regardless of what he may have done or may not have done or been involved with, we have a responsibility to him, to all the young people like him, to not only the 144,000 that voted for the COB, but for those who were not able to vote on that because they were too young or maybe because they weren't in the city yet. But regardless of who it is that is a resident of Davidson County, we have a responsibility to them. And I just wanted to share that the importance of this board and the work that we do. I just wanted to lift that up. So thank you for that time.
Thank you. Thank you for sharing those sentiments. And I think we would all agree on this board. And not only the importance of the work that we have been doing, but what we will continue to do, and what this fight for the Community Oversight Board looks like in the months to come. And I think we're all committed to that. So thank you for sharing your thoughts. Anything else? We are adjourned.
This has been a service of the Metro Nashville Network. If you would like to see this presentation again, or for more information on this and other programs, visit nashville.gov.